Thank you. Good morning. I've been out of the Department of Justice for almost a year now, but and even though I've worked as defending corporations for about 10 years, I often get asked to speak, and I was asked to speak this time to kind of give the internal Department of Justice guidance, review how things work, defend the Department of Justice and their actions. And I enjoy to do that, although I did note from Paul's earlier comment about the weed whackers on the panel. I guess that means I'm the weed for this panel. So I'm going to talk about generally, the Department of Justice. There is a framework for how prosecutors make decisions about whether to charge a corporation. And it's more of practical considerations than the legal discussions that you just heard from Andrew. But putting it into context, I'm going to talk a little bit about the genesis of that memo, the framework for it, the decision factors, and then maybe focus on, are these factors the right ones? What do they mean? And are they being implemented in a way that make people comfortable about the Department of Justice's decisions when it comes to charging corporations? So the framework is basically this. In 1999, Eric Holder, who was then the Deputy Attorney General, listed some factors that a prosecutor should look at when deciding to charge a corporation. And it was put out as guidance to all assistant U.S. attorneys across the country and all 93 U.S. attorneys' offices, basically meant to set boundaries on a prosecutor's wide discretion in this area. And that memo, that guidance to prosecutors, was then updated by Deputy Attorney General Larry Thompson after the Corporate Fraud Task Force was set up in 2002, after we had Enron and WorldCom and the other big high-profile disasters in the corporate world. It was then updated again by Deputy Attorney General Paul McNulty, dealing mostly with the attorney-client privilege and cooperation, and then it was updated again this past year by Deputy Attorney General Mark Phillip. And so it's kind of a living, breathing document. Having said that, the 9 factors that prosecutors look at have generally remained the same as far as the categories go. The external framework, obviously outside of the Department of Justice, while not relevant to prosecutorial decision-making, is important, I think, for this discussion, which is you have Congress that have passed statutes, criminal law, a corporation can be a person for purposes of the Federal Criminal Code. You've got Congress, who is constantly conducting oversight. The Department of Justice is not doing enough. It's the Department of Justice that should have been, regulating and prosecuting, and we wouldn't have the malfeasance and the financial crisis that we have today. Where was the Department of Justice on the mortgage fraud? So you've got that pounding that constantly goes on from Congress. Then you also have, I think, both this administration and the prior administration, lots of very high-level rhetoric about who's to blame for back in 2002, the collapse of Enron and WorldCom, and how are we going to hold them accountable? And today, who's to blame for the financial crisis, and how are we going to hold those people accountable? And how are we going to look at the corporation? So, and then, of course, you have the judicial decisions that have already been made. So you've got that whole framework. So in that context, what are the factors that a prosecutor has to look at? First is the seriousness of harm to the public. The seriousness of the crime. Is it a very high-level crime? What is the harm to the public? You're supposed to consider the acts themselves and whether they're a high-level serious nature. Second, was the conduct pervasive? What does that mean? That means pervasive throughout the company, whether it was one person, as Andrew said, or whether it was a lot of high-level executives where you could call it basically systemic behavior. That's the second factor that you're supposed to look at. Third, prior history of the corporation. Have they been at it before? Do they have outstanding SEC violations that they've settled, or other regulatory violations that they've settled, cease and desist orders, things like that show you that the corporation over time just isn't getting it, and they're constantly a repeat offender. Fourth is basically disclosure. Did the corporation come to the government and disclose this behavior? Fifth I think has already been talked about. That's the compliance program. Was there a pre-existing compliance program in place prior to the conduct at issue that was targeted at preventing the conduct? That's supposed to be a factor within a prosecutor's discretion that they're supposed to look at before they decide to charge a corporation. The next one is actually on the flip side. Did the company take remedial actions when they found out about the conduct? And what kind of remedial actions did they take? And did they show that their corporate consciousness understood that because a crime was committed at their company, they're going to take steps to prevent that crime from happening before? Maybe it's disciplining the employees, maybe it's doing a new compliance program, something like that, but it's remedial actions. The next factor is collateral consequences. What are the collateral consequences if you charge the corporation? Now, we all know with public companies, these are very, very severe collateral consequences. And, for example, in the defense contracting industry, you could get to debarment or suspension from doing any business with the government. So those kind of consequences are taken into account in their discretion. Adequacy of prosecuting individuals. That's another one that's one of the factors. It's a very interesting one. Basically, what the guidance says from the Deputy Attorney General memos is a prosecutor, when deciding whether to charge a corporation, should consider whether it can be adequate to just charge the individuals and not the corporation. And then finally, the final factor is whether there are other civil or regulatory things that are available to the government that might resolve this case. Should the SEC just resolve its case and therefore you really don't need criminal liability in this context? For example, that's how that works. Now, none of these factors take priority. So what the guidance tells you is that you're supposed to look at all 9 of these factors and you're supposed to make a determination weighing them, and they're not listed in order, and there's nothing that says, seriousness of harm is more important than a compliance program, or that adequacy of prosecuting individuals is more important than one of the others. How it plays out is very interesting within the department, and I think very important, which is, do all of these factors actually get reviewed on a case-by-case basis? That's what the guidance says. But I can tell you from my experience, it doesn't always happen. And that's not only the fault of the prosecutor, it's the fault of the defense counsel as well. When a prosecutor is making a decision to charge a corporation, they need to look at these factors. That's what their guidance tells them to do. Often, the defense counsel involved won't provide information about compliance programs, or it won't provide information about remedial efforts, or it may not provide an idea about how the civil regulatory scheme can take it into account. So I also have seen cases, unfortunately, where not all of these factors are actually given their adequate due on the side of the government. I think that that's true, that as these things get reviewed, and it's very serious to charge a corporation, discipline has to be given both on the prosecutorial side and on the defense side as far as how you're evaluating them. Because at the end of the day, the factors are, again, meant to limit, but the question is, are some of them really being given their adequate due, and are they too subjective from some perspectives? Now, you can argue, and I think Professor Parker argued, what does the government know about compliance programs? How is the government to judge what's the appropriate compliance program within a corporation and whether that's kind of adequate? Fair point, fair point. Maybe the corporation in this context needs to educate the government on that point because it is one of the factors. Maybe this shouldn't be a factor. Maybe, as Andrew said, it should be the only factor and it should be a slam dunk affirmative defense. I think that it's interesting that remains a very big issue, and quite frankly, in my job, I found it to be one of the most, as Andrew did, one of the most persuasive things a company could come in and say in arguing that they shouldn't be charged criminally is that they have a lock-stop compliance program that was impacted and directed right at that activity to target. Now, one of the other factors that I mentioned is the possibility of a civil resolution. And I guess the question for me is, how do you really evaluate that, given that most of the time the criminal investigation is going to go first before the civil resolution ever comes about. And the criminal investigation and decision-making is done by prosecutors who actually are not civil attorneys for the most part. So while you may have a U.S. attorney that looks at both the civil assistant U.S. attorneys and the prosecutors in his or her office, they're not necessarily talking about a case. So do you think that the incentives are correct, or are the incentives aligned so that that criminal prosecutor will actually step back and say, you know what, I think I'm going to let the SEC, or I'm going to let one of my civil AUSAs go forward with this case as a False Claims Act case instead of a criminal one, we'll go forward civilly. That can be proposed. It's not discussed enough. And I think that often because the criminal investigation goes forward first, before any civil or regulatory investigation happens sometimes, that sometimes waits, then I think evaluating whether that's adequate is somehow can lead to problematic things. I think the factor of, should the prosecution of individuals be relevant to the corporate case? I think that is also one that can be debated. And often, again, you don't know going in and going forward because the company wants to cooperate, and they may give you information about individuals. At the end of the day, you don't know whether you're going to go forward about those individuals, and the company wants it over with quickly because their stock is dropping, they need to resolve the investigation, and they need to get back to business. And so that one strikes me as also one that maybe is something that we need to think about a little bit closer. Now, stepping back from it, what do I think about the factors? I think they're good ones. And I'm not suggesting that there should be other ones or different ones. I think that we can debate which ones should be prioritized. I think it's very good and very important that the Department of Justice has bounds on their discretion in this area and that there is guidance provided on how to exercise the discretion. I think that's very important because I think otherwise you're going to get 93 different U.S. attorneys' offices with, thousands of prosecutors, just making a decision without any guidance, without any framework. So I think it's very important and very good that we have this framework. It's often suggested that maybe the Department of Justice headquarters in Washington should review any charge of a corporation. It happens sometimes. Sometimes if a defense counsel has a client that's about to get charged, they will request an appeal at Main Justice, and they'll come up and see the Assistant Attorney General, and they'll argue why their case should not be indicted. But the majority of cases are decided in the field as to whether that corporation is going to be charged without any review in Washington. So the question comes up is that enough? Should we think about setting a national standard? I will tell you that the downside of it is when you bring things to Washington to try to bring some, real stricture on the policy, many people say that that's politicization, and you can't be making decisions in Washington that are affecting the local communities. It's almost a federalism issue, but within the federal system. It's very dangerous to kind of take that prosecutorial decision-making out of the hands of the fields and center it only in Washington. So I'm not advocating a national standard, but I think it's something that should be debated and continues to be debated. So at the end of the day, I think a couple of things. Number one, I think it is important to limit the discretion in these matters, and I think that the Department of Justice needs to continue to review the guidance and continue to think about how it's being applied, continue to train U.S. attorneys and assistant U.S. attorneys on these matters if they are going to charge corporations criminally, because many AUSAs have never worked inside of a corporation and never worked in a law firm defending corporations. So it's important that that education process and that training process from within the government is really focused and targeted on this issue if corporate criminal liability is going to continue.
Okay. Thank you, Alice. Appreciate that very much.